This meeting of the Anderson Township Board of Zoning Appeals is hereby called to order. This board was established pursuant to Section 519.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Mr. Halpin?
Present.
Mr. Graff?
Here.
Ms. Wagner?
Here.
Mr. Sion?
Here. Thank you for coming to this meeting of the Anderson Township Board of Zoning Appeals. Please be aware that this meeting is audio and videotaped and may be carried live on television. First, I'll outline our procedures. A summary of the appeal is presented by the staff, and the appellant will present its case. The board members may then ask questions of the appellant. After that time, all persons supporting the appeal will be permitted to testify one at a time after being recognized by the chairman. When those persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and/or ask questions of the board after being recognized by the chairman. All persons wishing to testify, whether for or against an appeal, may only do so after being sworn in. When testifying, each person must come forward to the podium after being recognized, the podium right here in the center, speak into the microphone and state their name, address, and any affiliation to the case. All persons testifying will be limited to 4 minutes unless a board member requests additional time. All testimony is given to the board only. No comments or questions are to be directed to the appellant or anyone else in the audience. The board will only hear new, non-repetitive evidence or questions. Should someone wish to show support of previous testimony, they may do so by following the testimony procedures and stating their support of previous testimony. Now, will all persons who may give testimony this evening please stand, raise your right hand, and swear or affirm you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do. I do.
Are there any changes to tonight's agenda?
The only change will be the election of officers at the end of the meeting. We've decided to move that to February.
So noted. And we'll go with the approval of the minutes from December 7th, 2017 meeting.
I'll move approval.
Are there any changes to the minutes?
Nope.
Do we have a second?
I'll second.
Please call the roll for the approval of the minutes.
Mr. Halpin?
Aye.
Mr. Graff?
Aye.
Ms. Wagner?
Aye.
Mr. Sion?
Aye. And will the staff please read the summary for the case number 23-2017 BZA, and are we doing both 24 and 23 together?
Yes.
Okay.
So tonight we have a continuation of two cases from last month, case 23-2017 BZA, which is for lot 22 Riverby Drive, which is a variance request for a front yard setback of 28 feet where 50 is required, and case 24-2017 BZA for lot 23 Riverby Drive, which is a variance request for a front yard setback of 20 feet where 50 is required. So before we get started, I would like to present a couple of pieces of new evidence to the board. The first being a letter from Mr. Phil Finn, who's the property owner of Lot 20 on Riverby Drive. The second being a letter from Hillside Trust in regards to both Lot 22 and Lot 23. And just for clarification from the last meeting, Hillside Trust is a nonprofit organization which advocates for the preservation of hillsides, whereas Hamilton County Soil and Water are the authoritative body in regards to earthwork decisions. So they perform plan review of new building applications and earthwork applications to determine the level of compliance within Hamilton County earthwork regulations and issue permits in accordance with sediment and erosion control standards. The third piece is an elevation drawing provided by the applicant. In addition, there have been previous conversations about height, and I would like to state that the Anderson Township zoning resolution defines height of building, which can be found on page 144 of the zoning resolution, as the vertical distance from the average grade to the mean height level between the eaves in ridge of gable, hip in gable roofs. Also, staff feels that it's important to note that per Article 5.2B1D of the zoning resolution, that private drives provide access to 3 or more lots shall be considered streets for the purposes of establishing setbacks and yard requirements, which we've been applying to both Lot 22 and 23. So I have the presentation from the previous meeting, so if there's anything that the board wants to see again, all the pictures are in it, the whole staff report, and case findings before public hearing.
Okay. My understanding, Mr. Graff, you've viewed the...
I have, yeah. I wasn't present at last month's meeting, but I went through the video of the entire meeting minutes. I read through all the documentation, and I went to Riverby Drive. I went to the site yesterday, verified, saw firsthand what we're dealing with.
Okay.
So I feel good about making the decisions.
Thank you. Does anyone from the board need a review, re-review from the staff? Are there any further questions of the board?
Well, I guess, we're seeing this Exhibit A for the first time. I guess I'd probably need a moment to digest what we're looking at here as far as that elevation that we're talking about. So this is for this pertains to lots 22 and 23? Is that correct?
Yeah.
Yes.
While you're reviewing that, just for the audience, this is a continuation of the 2 cases. So last month, during the public hearing, any testimony that was given carries over in the record tonight, so there's no reason to repeat information that was presented last month. The board did keep the cases open, so they will take new testimony tonight. But just so you'll know, anything that was stated last month carries over in the record and is presented or represented in the minutes that were approved tonight. So there's no need to repeat, what was stated last month.
Any other questions of staff?
So this that we've been presented with, what are they saying? I'm not quite sure. Are they arguing that the house is not going to be proper height on the lot? Or I'm not quite sure what this is all about, this drawing.
I think I think those questions should be directed to the applicant, and the applicant can explain the drawing.
Okay. Well,
If you're ready, if you're ready for that.
Oh, yeah.
Okay.
No further questions of staff?
So this came from the applicant, is that correct? Oh, okay, I misunderstood that.
And it has both the property line, the setback 50 yards from the property line and from the edge of pavement. So which are we, what is the
Well,
zoning?
50 feet, not 50 yards, but yeah.
Right.
From the edge of pavement.
Edge of pavement?
It would be taken from the private drive rather than the property line.
Okay.
Are we ready to call the appellants forward?
Yep.
Would the appellant or appellant's representative please come to the podium, speak into the microphone, state your name, address, and any affiliation, and present your appeal, please?
Hi, my name is Stan Messerly with Mesco Engineering. Address is 2766 Wasson Road, Cincinnati, Ohio. I'm the civil engineer for the applicant, and do have some additional information I'd like to present to the board. I do have some packets. One of the 3 new items is in reference to that Exhibit A that you're looking at now. The other information, one pertains to a response to the letter we received yesterday relative to the Hillside Trust, and the third item that I've got information relative to is the protective covenants that are record for the subdivision, and I just wanted to emphasize to the board that what we're proposing does not contradict or violate anything that's contained within those protective covenants. So if the board would like, I'd be glad to provide you the information.
Thank you.
So, of course, you just have a cover letter there. I'd prefer maybe to open up the large drawing first, and that drawing is intended to be in reference to the Hillside Trust letter that was received yesterday from staff. And you'll note on that drawing, that's a drawing that's part of the covenants that references the various easements that are of record for the Rio Grande subdivision, blocks A and B. And I've highlighted with a green highlighter a line which represents what's called the slide area, which was determined by a geotechnical investigation, which was accomplished prior to the subdivision being approved by the Hamilton County Planning. And you'll note that that slide area is outside, well outside of the area of our proposed variance lots number 22 and 23. But there have been indeed, prior to the subdivision, a geotechnical report provided by H.C. Nutting. Again, that was what was used to determine the slide area as well as the overall feasibility of the subdivision, in particular relative to geotechnical engineering. And then there are also, I'm aware of at least 2 other geotechnical reports that were provided for lots in the subdivision. And as you can note, you I'm sure have noted, the vast majority of the subdivision contains houses. I believe there's 19 of the 25 or 24 lots have houses on them currently, just in reference to the Hillside's trust concerns relative to the overall stability, hillside safety factors, and so on and so forth. So we wanted to present that information to the board. Also have some information in there relative to the protective covenants and what was recorded with the easements. In particular, I've highlighted the setback that's of record for the front yard for lots 22 and 23. And you'll note on that setback that the recorded easement drawing shows a setback front yard of 30 foot. Just wanted to demonstrate to the board that, that what we're requesting for the 50 foot off the property line is in excess of what the covenants requires over the 30 foot setback off the northern property line. And then, unless you have any questions on those 2 articles, I'd like to... Where's the reference to 30 foot? It should be something I've written down there. It's right here. So that's for the protective covenants,
Yeah, it talks about normally have depth of not less than 50 feet.
That's correct, but then if you continue on to the charts that are shown there, that's part of the same protective covenants, and on there they have what's called a building line, and that building line says, the various setbacks, the front yard 50, and the side yard's 25, rear yard is 60, I believe, in that chart, and it continues to say, or as approved by Hamilton County Planning Commission. And then the recorded drawing, the plat, shows the building line to be that 30-foot offset that we just looked at on that one drawing. And what we're requesting is a 50-foot offset off that northern property line.
For the board's purposes, just so you know, you're enforcing the Anderson Township zoning resolution, not the private covenants. So even though the private covenants may say one thing, you're bound to adopt or deny the variances based on the Anderson Township zoning resolution, just in case you have any issue about that.
We just wanted to try and demonstrate that we weren't trying to override or get any sort of variance that would be in contradiction to what's in the approved covenants.
So the 30-foot line that you show on this large print,
That's
is that a setback from the edge of the pavement,
that's from the northern property line?
the northern property?
Yeah, because when the subdivision was really originally recorded, actually, the Hamilton County zoning code did not make a reference to the front yard setback as off of edge of pavement, would have been off the property line. But since Anderson Township is now the governing authority for the zoning, we would be required to follow the Anderson Township zoning.
Is that the sum of your testimony?
No, if you don't have no more questions on those first two items, I'd like to address that Exhibit A then.
Yeah, well, generally, you hold questions until the end, and until you're
Okay,
done.
sure. The Exhibit A is an exhibit, if you recall, the reason why we requested to extend the hearing over to this month was because John Adams and his wife Monica Adams, the applicants, wanted to do whatever they possibly could to appeal to the adjoining property owners and to make certain that they were in approval of the requested variance. And one of the means that we utilized to acquire this agreement was to limit the elevation of the either the midpoint of a gable or the high point of a single slope roof. And we've reached that agreement, so that Exhibit A is a document that's intended to detail the agreement that we have reached. So on Lot 22, you'll see where we've reached an agreement of elevation of 632, mean sea level for the height of the midpoint of the gable of the proposed house, and the same elevation for the high point in a single slope roof. And then for the Lot 23, the agreement with the adjoining property owners was reached at an elevation of 628. And both property owners are at this meeting, and I know staff has already referred to the one letter from Mr. Finn, and the other adjoining property owner was Linda Weber. So that's the extent of the new information we wanted to present tonight.
So there is correspondence from Linda Weber as well in agreement to that height?
I don't believe we have one, but we do have her in attendance. I would suspect she would be glad to testify to that fact.
Do we have an exhibit for Lot 23?
It's the intent that that document addresses both lots. You'll see a note number, or a letter B, which addresses Lot 23.
Right, showing the elevation of 632, but you said for Lot 23, it'll be 620.
Yes, if you look at note B on that drawing.
Here. Mine says 632. Oh, this one. All right.
Could you define, you mentioned this area highlighted in green about being the slide area.
They call that a slide zone, I believe, in the protective covenants.
So that's the only area that was addressed regarding the geotechnical aspect of this? is that
No,
correct?
the entire development was addressed as a geotechnical investigation for the original subdivision, and through that investigation, they identified that area that's within that green line as a, I think they call it a slide area, where structures were prohibited from being built.
So the testimony we had last month from Linda Weber, she's, let's see, that's Lot 14, is that, no, let's see here. Was she Lot 14?
Yes,
Lot 14?
yes.
So I know it was mentioned about having slide issues, and that was addressed over the last year, I believe it was. That's not related to this at all. Her issues are related to hillside slippage.
I couldn't answer that. You had to ask
Yeah.
Linda.
Okay.
Are there any more questions for the appellant?
Mr. Chairman, if I can make a clarification from a legal standpoint, Mr. Messerly, are you saying that if the variances are approved for lots 22 and 23, that the Adams, or the property owners, the entities that own those properties want or agree to have this as a condition to those approvals?
Those elevations of 632 and 628, that's correct.
Okay, thank you.
And Mr. Adams is here. I'm sure if you'd prefer, he'd be glad to say the same.
Thank you.
This might be a question for Mr. Adams regarding the development of these two lots, 22 and 23. Are there plans in place to develop those? Is that, maybe he should approach, I should ask him that question.
My name is John Adams. My address is 7360 Riverby Drive. I live in the community on the street. That's where my wife and I live.
Also, you live in this?
I live in the subdivision.
You live on
So
20. You live on lot 20.
7360. I don't know what the lot number is.
Is that lot 20?
No, I don't, lot 20 I don't think is developed.
I live in lot 7, 7360.
Oh, okay.
So with regards to the two lots, my wife and I own 3 lots total on that street. We bought one lot, and then we bought a house to live in while we built on the other lot, and we kind of got sidetracked with wife and kids and stuff, okay? And we bought these additional 2 lots. So we, my wife and I, are going to build somewhere on that street. We'll stay in the house that we're at until we build. I've got a buddy who would like to end up in one of the lots himself. And what I'm trying to do is, I'm sorry? I'm trying to make it easy for whoever ends up building at that lot, be it myself or be it a friend or whoever. But we live in that development, and I want to be neighborly. I don't want to hurt anybody, and that's why, the folks behind me I consider friends. We try to get to a point where they're good, we're good, so.
So really, you're here looking for a variance so that you can have a 20-foot setback on one lot and a 28-foot on another lot.
That's correct.
And that's the reason you're here in front of us.
That's correct.
You're not here in front of us regarding height of house. You're not here in front of us regarding slippage or hillside instability. Is that correct?
That's correct.
Okay. I'm just curious.
Okay.
I just wonder why you're here.
Yeah.
And that's why.
Yeah.
It's just for setback purposes.
Yes.
Okay. I'm sure there'll be somebody who'll say something different, but we'll go from there.
Yeah. Thank you.
Thank you.
Are there any more questions for the appellant?
No.
Being none, are there any more who wish to speak in favor of the variance?
My name is Linda Weber. I'm at 7341 Riverby, also known as Lot 14. To address the question around the landslide issue that I had, it had nothing to do with the geotechnical. It ended up being, when the engineers went in and investigated what the problem was, is when they cut out the private drive, they dumped the fill into the backyard of the house, which should have never been done. So I had no legal recourse, but that is why we had landslide slippage where they had incorrectly done the backfill on that one. As John mentioned, we have had lots of discussions, and I did not get a letter to the board in time. I am in complete agreement. To me, it really doesn't matter where on the property he builds. My concern was more about height neutrality, and John and Monica and Stan have addressed that in Exhibit A.
Great, thanks.
Any questions for this individual? Okay, thank you. Anybody else wish to speak in favor?
My name is Phil Finn. I'm at 7300 Riverby Drive, Lot 19. I also own Lot 20, which is directly north of Lot 22. If you look at the history of Rio Grande subdivision or Riverby Drive, there were 4 homes that received variances. In every single case, there was no blockage of the river view, which we think is imperative, and that's what we're trying to prevent today from happening. And working with Mr. Adams. Then I've come to an agreement where if he can restrict the height of any structure down there, in my case to 632 feet, mean sea level elevation, I would be in agreement to let him build on Lot 22 based on the other parameters by the township.
So your issue is primarily with Lot 22, not 23?
That is correct.
And with that height restriction, it lessens any concern you have about constructing on Lot 20.
That's correct, yes.
So that would meet the height requirement. I know it was discussed last month about accessing that lot from the road or from the private drive. Based on the height limitation, is your expectation that it would probably come from the top down?
Well, I don't want to say it would be top down or bottom up, but the point is, no matter where I build on that lot, if he keeps the height to 632 or less, it's not going to block my view.
It gives you the latitude to build on the lot
Yes.
without
Yes,
obstruction
sir.
of view.
Correct.
Any further questions?
Thank you.
I have no questions. Thank you. Does anybody else wish to speak in favor of this appeal? Please step forward, state your name and address.
Good evening. My name is Dave Davis. I'm at 7351 Riverby. I'm the eastern neighbor of Linda, and I'm the southern neighbor across the street from John and Monica.
Do you know your
Would that
lot
be
number?
lot 12 possibly?
I've only lived there 16 months, so
7351?
somebody help me out.
You're lot 12 and half of lot 10.
I've been told I'm half of Lot 10 and
Okay.
and also Lot 12.
Okay, so you're near the slide zone.
I am. One of the things that I had, and I'm glad you brought that up, Mr. Halvin, one of the things that, when I had an engineering firm come in and evaluate, and this was prior to knowing any of what Linda had, and long story short, the people who did my house prior to my being there did overkill. The guy said, unless I'm going to live 500 years, you have absolutely nothing to worry about this house moving at all. So I don't know how many great-grandchildren away that would be that might have an issue someday, but for me, it's, they said it's not going anywhere. Where John and Monica want to build, there's one more property around the corner, and they've done substantial work down there to make that a beautiful residence now and cleared it all up. And the way it is, the only person who's ever going to see these houses is going to be the person who's at the very end of the street that's going to move in there, especially with the height limitations and those types of things. So, and what it does too is it tucks the houses in closer to the hillside too, instead of sticking them out more towards the river. So from everything I've seen, again, it's just walking down the street and looking there, it looks like great to me. And the property values of these houses, they're going to be substantial houses. They're only going to increase the value of the neighborhood too. So in my expertise opinion, it's a great thing to do. Thank you.
Any questions for this individual?
No.
Thank you. Anyone else wish to speak in favor of this appeal? Seeing none, anyone wish to speak in opposition to this appeal?
You want me to go? I wasn't here last time, so let me get myself. Can you move that map a little bit? Is that only, can you move it to my left? Is that possible?
We'll bring up a different map.
Okay, well.
While we're doing that, can you please state your name
Yeah,
and address?
my name's Bob Betts, and I live at 7361 River Point Lane, and it's the subdivision over from that, so you might wonder, why am I here? Here, I got this map. You see, this is our home is here, and we bought this lot and this lot to protect our view. So where they're talking about the homes are this, over here, see? So if you stand on our deck, you can see the house that's in here, okay?
And we'll need you to stand and speak in the microphone too,
Okay.
because this is being recorded.
So,
She's bringing.
and we've lived in our home for 30 years, so we're longtime residents there. So, my concern is the geology, and I'm opposed to it because this is all a slip zone. I know people have tried to define different, but I've had a landslide, so that's what I'm here to tell you about. This is, let's see. Make sure I can. Again, I've only had one copy, but this is from the website of Hillside Trust. If you, I apologize for coming up here, but, this is the kind of slide you get right there, and I'll show you. So here is your copy there's one copy of all of this, and I'll work for. Back in 2011, there was a really heavy period of rain, and so we had a landslide. And at that time, we had Thielen, who, again, when we bought the home 30 years ago, we had Thielen come out. They're an engineering firm, and their invoice is in there. And they came out to look at the slide and basically said that, can we see my house up there, or our house? Yeah. Now go up, right there. Is that our house? Yes, that's our house right there. So, and then we own the property to my right of that. We own that lot, and now move over again, and we own this lot. So that's the one that's contiguous to Riverby. So, in 2011, we had a landslide. You'll see in the file there, we had Thielen come out and take a look at it. And their approach, and I paid for a draftsman and a secretary here, but I can't find the report. But they wanted to pier, basically. And I think you're familiar with that, where you go down, all of this geology, you've got a lot of topsoil on shale, basically. And you can see that as you drive along 52. You can see the shale. And if you drive out from Eastern Avenue, you can see the landslide that they've had along right where the Verdon Bell used to be. You can see where they've had to go back into the bedrock to hold the hill. So, I think the whole region is pretty unstable, and that's what the Hillside Trust talks about. So we had Thielen come in, they suggested piering, and basically it was a $60,000, $70,000 expense. And I was going to share it with our neighbor because this you'll see in the map, you can see a diagram there from, then I said to myself, before I spend $70,000 or 60, then we were going to look at, was there a better way, a cheaper way to do it? So I said if we could get the water off the hillside, that would help. And Jeffries Engineering there, they came out and took a look at it. And this is described in his memo there, you can see it. They basically, he said he would agree that is a good first effort, and it may or may not work in the long. It's worked for 5 years, basically. But then what we did, and you'll see the diagram in there, was put drainage ditches. Actually, there was a third one put in between the two that are shown in the diagram there. And, that was about, we shared that expense with our neighbor, Bob Sullivan. It was, I think my side was about $6,000, $7,000, so it was a better deal than $60,000. So, I'm concerned about the geology of that hill. And I'll show you some pictures. I brought some pictures too. Because the hill continues to slip.
If you could, just please start at the end there, and they can just...
Start it down there?
Yes, just start it.
Okay. This is just a pier on our deck. And if you look at the top of that picture, that whole pier has gone down about 6 inches since we've lived there. So when the first time we had a builder come in, he said, that deck isn't level. So he took the bolts out of the pier and the whole deck sprung up, so we had to, you could see the block there at the top of that pillar. So that whole, and if I showed one pillar, the worst one, but they all had to be leveled up over a period of time. I think you can see some of this. This is the house, and I took the picture down by the lots they're talking about. That house, and it's pier. You can see the piers in the background. And so, I think that some concern has to be expressed. From my personal standpoint, you'll see as you read the Jeffries letter, or memo, I mean, he basically talks about the fact that, yes, you've stopped this, but you really never stop it. If it goes again, I'm going to be piering it at whatever it costs today. That was 5 years ago. A lot of money and a lot of concern on my part. These are very steep lots. Don't kid yourself. I mean, here's a picture I took. That's either lot, it's at the base of that private drive. So you could say to yourself it's going to be built one way or the other. Okay, fine, and that's true. But I would say that if you adhere to the variants that are in the code, you've got a better chance of forcing the people to build it properly. You have a quizzical look on your face. Do you see my reasoning on that?
Well, no.
Well,
The only thing,
why would you want a variance otherwise?
well, they want a variance because they want to build closer to the road.
Because it's easier. It's lower cost.
But they've got experts and you've got experts, and we're not experts.
I understand that. Is there any obligation on the township standpoint to get experts?
According to this one document here, yeah, they're saying we have an obligation. And
As a resident, I would agree with that.
quite frankly, I thought that if you hired the proper geologists to do the job, then we shouldn't even be involved in that point or that part of that decision.
I don't know.
My decision,
I didn't.
in my mind, is
I'm not building on these lots. Okay. I didn't. If I were, I guess I'd get a geologist to prove the point.
Right, and I think, isn't that what everybody's doing?
Excuse me?
Isn't that what everybody's doing?
I don't know. Is that what was represented here? I didn't hear that, but is there did a geologist look at this and say that ground's stable?
Well,
I would think there's an obligation to do that.
One would suggest that if you adhere to the 50-foot setback versus 20 or 30 or whatever the number is, if you're going farther down the hillside, you would need to pier it or do more because
I would agree.
you have a greater issue with
I would
slippage.
agree, and I think that's probably a good thing.
So the logic in my mind would, if you're moving farther up the hillside, closer to the road,
You do less?
you would do less. Now, we don't know that.
Well, I don't know it either, and as somebody who owns a lot of property around there, if that slips again, are they going to pay for my slippage? I don't think so.
Let's confine the meeting just to asking questions. We will deliberate later.
Okay, enough said. Okay, thank you for listening.
Any further questions for this individual? Seeing none, are there?
Excuse me.
No, thank you.
Okay.
Is there anyone else
Here's
who's?
your documents up here.
No, those are yours. That's all yours.
Except for the map, that's mine.
Oh, the map's his, okay.
Oh, that one there.
The big map.
Is there anyone else who wishes to speak in opposition of the appeal?
Good evening, Mr. Chair, members of the board. My name is Joe Trouth. I represent Ken Oakes, who lives at 270 Sunny Acres Drive, excuse my cold. I first had a couple procedural matters. I feel at a disadvantage because I haven't seen the minutes to see whether they, in my opinion, accurately reflect what was said last week. So I would reserve the right to review those minutes and be able to submit as part of my testimony comments, on that if necessary. That's number one. Number two, I haven't seen what the applicant submitted, and I'd also reserve the right to comment on what the applicant submitted. I think your counsel correctly stated that the covenants do not trump your zoning code, and that's really what we're here about today. And the two variances are 22 feet and 30 feet. I think it was misstated before as 20 and 28, but it's a 60-foot variance and a 44-foot variance. So we got 60% variance and a 44%, which is 30 feet and 22 feet. I'm here strictly on legal matters. The applicant, as your counsel will instruct you, has the burden to prove the elements of your code and totally failed in that respect. Your code in 2.12 states that these number of conditions must be proven by the applicant to be entitled to a variance. Number one, the property in question, did the applicant full well know the condition of the hillside at the time they created their own hardship and therefore can't ask the board for a variance? You can't buy something, create your own hardship, and then come and ask for help. That's clear in your code. Number two, the variance is very substantial. This isn't a minor variance. When you're talking 60% and 44%, that is very substantial. And they have not proved that it's not substantial. Criteria number three is the most important of all, and you just heard testimony about that from Mr. Betts. Criteria 3 under the code states that the essential character of the neighborhood would be substantially altered and whether adjoining property owners would suffer a substantial detriment as a result of the variances. We've heard from the Hillside Trust that the hillside is unstable. We've heard from Mr. Betts that the hillside is unstable. We've heard at the last hearing, we heard about the whole history of Mr. Thule, who was in litigation for years as a result of slippage. The applicant has a burden to show that they meet your code, and they have not done that. They have not shown any geotechnical studies as to what would happen if they build where they're supposed to build or if they build where they're asking you for a variance to build. We don't know what the effects of either of those are and what the cost of piering would be in either case. So again, we've got the cart before the horse, the applicant asking you for help before they have shown that they've met your code. Number 5, the owner did purchase the property knowing the zoning restrictions of a 50-foot front yard, not what's stated in the conditions of the subdivision. And they now ask for a 60 and a 44% variance. So they've not shown any of those things in your code. I'm just asking you, please read your code and say, has this applicant met our code? Because otherwise, if the code is not followed, that is a very, very dangerous legal precedent. And I'm saying that your code states exactly what the applicant was supposed to show, and they did not. And all they have to do is do some geotechnical studies, say, here's where we want to place the house, here's why we have a problem. But they bought these lots knowing that there's slippage in this area. I think it's very ominous that the Hillside Trust wrote this letter clearly stating what should be done. And I'm just asking this board to follow the code and follow 2.12 and read it carefully and say, did this applicant meet these sections of the code? And you'll find that this applicant did not meet any of those sections of the code. And I think it must be denied until the applicant does that for you. Thank you.
Any questions of this individual?
So, I guess you're talking about 2.12, that code is the setback code?
That code is the criteria that you must follow in order to grant a variance, and it's the code that the applicant must follow in order to be granted a variance.
Okay, so what do we have to follow, or what does the applicant have to follow?
Well, the applicant has a burden to prove those points in the code in that section. They got them listed. And the applicant has to show that when they bought these lots, that they didn't know the conditions, that they didn't know that the zoning setback was 50 feet, that they didn't know that they couldn't harm anybody else in that area, you know, with regard to slippage and all that. So, you know, it's clearly set forth, and I don't know if the staff has given you a copy of that.
It's on the screen there.
Oh, there, yeah, here we go. The property in question will yield a reasonable return, or whether there can be any beneficial use of the property without a variance. Well, they didn't show that. I mean, all we heard is the applicant said, well, it might be a little bit more costly to peer down the hill. We don't know what the numbers are. We don't have a clue as to how much peering has to be done as the lot sits or as the variance requested. Is the variance substantial? They didn't prove that it isn't, and a 60-foot and a 44% variance is substantial. The essential character of the neighborhood would be substantially altered, or whether adjoining properties would suffer a substantial detriment as a result of the variance. This is what we're talking about. This is what Mr. Betts said. He's concerned about the hillside. This is what the Hillside Trust said. They're concerned about the hillside. So why put the cart before the horse, grant someone a variance without them meeting the specific conditions of why you can grant a variance? The property owner purchased the property with knowledge of the zoning restrictions. You're put on notice, you got to be on notice of the zoning restrictions. The property owner's predicament can be feasibly obviated through some other method other than a variance. We don't know that. We don't know that. We don't know. I mean, it might cost, you know, more to peer uphill than downhill. We don't know that. There's been no evidence presented to you. That's what I'm saying. They have the burden of proof on all of those points, and they have not met any of them. There's no evidence in this record that anyone can rely upon that they have met those 7 conditions. And the last one, the spirit and intent of the code would be observed and substantial justice be done by granting the variance. Well, you got to meet all the other ones first. So, again, I mean, you know, the code is very, very specific in what they had to do. They did not do it, and what you have to review when you grant a variance. So it's not just saying, yeah, we'll give it to you, you know, we'll help you out. Again, there's testimony at the last hearing as to what the one lot was purchased for. I think it was $45,000. It was less than that even, I think. No, it was, yeah, $45,000 for 1.1 acre lot. They knew what they were getting, and they can't just come then running to you and say, hey, help us out. They got to meet
So
all.
are you saying then that the purchase price of that lot, that 1.25 acre lot, was reflective of the fact that that lot had a problem?
Yes.
So is that?
Yes. So they knew full well the condition when they bought it.
So they didn't just find somebody selling a lot?
No, I mean, they bought 2 lots, you know, and they bought one lot in connection with a house, and the combined price was $387,000 or so. Yeah, $387,000.
Is your client, how is he related, he or she related to this whole project?
How's he related to the hillside?
Yeah.
Well, he lives on the hillside. He's concerned about the hillside.
And his land, the
It's up
lot he
further.
lives on?
It's up further. You can see it on that. It's marked on the paper map that I have there.
And he's on, what his address?
270 Sunny Acres.
Sunny Acres?
Yeah.
Keep going. My right, the other one. Keep going.
No.
To my right. You're,
Just to the left of that sheer view where...
yeah. That's the house right there.
Wrong direction.
Yeah, just get ready to roll.
Not Indiana, West Virginia.
Keep going.
See the word sheer view?
There you go. Now, right there. That's his house.
Okay, so,
He's up a ways, but I mean, Mr. Betts is adjacent to it.
By
So-
the way, I don't know him. I don't know his client. You know, that was brought up.
but who owns all this land down here? Who developed this down?
I think, according to the restrictions that we looked at, I think Mr. Thule's company was a developer, and that's where the conditions came from that they were referring to, you know. But the conditions don't trump your zoning code, so, you know, whatever the conditions say, it doesn't matter. And Thule was the one that got sued. He's the one that had all kind of problems with slippage. I'm just saying, it's a very serious problem, and an applicant has a much higher burden of proof to come in and prove that they can meet all the conditions of the code.
Because it's on a hillside.
Yes, oh, absolutely, yeah, absolutely. That's the whole legal issue here, because of the hillside slippages. That, you know, there's a past, I mean, 2011, you know, 6 years ago, there was a slippage, and...
You want to see what that slippage was?
Didn't you show it to us in a picture?
No, I never showed you the slippage. I didn't show where it was.
Oh, these pictures here are other
Yeah.
hillsides, not your hillside.
No,
You have it, go ahead.
yeah, here, go ahead. You'll see, where's the point?
Let's finish up with the first
Yeah,
producer, and then I need to ask the board, are there any further questions for this individual?
For Mr. Trout?
Yes.
Here.
I do have one question for Mr. Trout. You had mentioned about the setbacks. I believe you were saying 60 and 40 feet?
No, percent, 44% and 60%.
Percent, okay.
So
Sorry.
the 30 feet setback is 60%, and the 22 is 44%.
Okay. Our numbers are 20 feet and 28 feet, correct? Okay.
I'm sorry.
Based on the plan that they submitted, they are requesting a 20-foot.
He's talking percentage, you're talking feet.
Yeah, is that a new plan?
No.
Okay, all right. Somehow I got that out of some document there, anyway. All right.
Thank you.
All right, if you move the pointer to my left, okay. Keep going, keep going. All right, keep going. All right, that's my house right there, our house, my wife's here too. So now move down, okay, keep up a little bit, right there. From the edge of my lot, and it went over to Bob Sullivan's lot, it went over his garage is the thing that sticks up there. So it went over, go down a little bit. Now, go to my left again, west, the other way. Okay, no, the other way. There you go. Keep going a little bit. Okay, went from there, now go into my lot. Okay, a little bit further, right there. So that slipped about 2 feet. You know, when that happens, if we didn't buy that lot, that's where a house would have been. Generally, as you increase the weight, what causes this is, you're sitting like this. On mine, it was the weight of the water and the soil. And that shale gets like an ice skating rink, down like that. Now, the more weight you put on that, the more it's going to slip.
In the picture you showed us that showed your deck, it was up on your lot.
Is on my, it's, where were we?
Right there.
Yeah, right there. Right, go down a little bit. Go to the left. My left, excuse me, a little bit more. You see, yeah, right about there is the edge of the deck.
That's easier.
Is this a pointer?
Yes.
Oh, okay, right there is the edge of the deck. Okay.
Are those events related, the slippage of the
I think the
hillside?
slippage of the deck's continuous. Like I say, it was about 6, I apologize. It probably, I'm trying to think, the first time we had a builder in for another reason. He said, your deck's not level, you know. So he took all the bolts out, holding it together, and the thing sprung up like this because the post had dropped about 3 or 4 inches.
Where's Riverbeat, using your pointer, where's Riverbeat to you?
Right there.
That's it there?
Yeah, right there. So that it's the property we own from that lot, that lot, and the one, that, now we own the next one, there, too.
Okay, and then the rest of those, so there's already houses on these lots?
There's a house right there, and that's pier.
Contiguous.
That's the picture I showed you with the pier.
Okay, so the 2 houses that are contiguous to your 1 lot there, is that a house at the end of the, at the cul-de-sac there?
That's at the end of Riverby. If you drive around Riverby, you'll run right into that house.
Okay, so you've got a house there, and then you've got the house lower.
Below it, that's it.
Yeah, and that, you're saying this lower house here had slippage?
I don't know. I don't know. It had piers. If you look at
Okay,
that picture I gave
so
you,
then,
that's all pier.
the contractor did their job?
Yeah, I guess so.
Put in the proper piering?
Yeah, I guess so, yeah.
So, then the other lots, 23 and 24, are down below there? I don't know. Is that 23 and 24?
Yeah, that's it right there.
22 and 23?
Yeah.
Do we know how long that house has been there, the one that you showed us the picture of?
I don't. I think before we were there. That's been a long time.
More than 10 years?
Yeah. Yeah, about the same time as we built our house. Yeah.
And so, I guess your concern is for these lots, for the people on these lots, not for yourself.
Well, look, I don't know. Let's turn the argument around
Well,
and say,
I'm trying to figure it out.
well, it's easy. Do those lots have if they slip there, will it impact my property?
Well, way up there.
Well, but wait a minute.
Built between you and.
Township wants to write me a guarantee that you hold me harmless. It's fine with me.
We don't do that.
Well, okay, but you're not going to pay my bills if it slips either.
Yeah, but you're saying without substantiation, that these 2 lots down here, if they build on those lots, they're going to impact your lot way up there.
Yes, could.
Okay.
What substantiation do you have that it doesn't?
Well, that's the whole point.
Exactly.
The point is that we're not here to make that determination. You see?
Well, I don't know
I'm
who
not a
does.
geologist.
I'm not either. I'm a chemical engineer.
But there's a house right between you.
Well, it's piered.
Right, well, okay.
Well, what's your point?
I guess my point is there's a house that's been built between you and the lots.
With piering to hold the hill, and if the hill above it lets loose, it's all going to go down.
Let's keep this down to questions, and I think we've...
Yeah, I mean,
I'm just trying to understand.
you made the point last, I watched it on TV, you made the same point. But, so I don't agree with that point.
Okay.
Okay.
That's acceptable. That's why you're here, and that's why this process is open. So time to
Move on.
move on. Are there any further questions for this individual?
Which one?
Seeing, either.
No.
Seeing none, is there anybody else who wishes to speak in opposition of the appeal? Seeing none, does the appellant wish to come back and address anything that was stated before? Please.
Stan Messerly again. Just a couple of things here. I know you had the slide shown for your zoning resolution 2.12, and just, I'm sure you were able to read it, but it does say items that are to be considered and weighed. I didn't see anywhere where are to be proven. And then also, and it also ended with saying not limited to those items also. Relative to the geotech, and in general, as was stated earlier by the staff, and the question answered by the board, we're only looking for a variance from the setback. We're not looking for any variance from any earthwork regulations, any building code regulations, in particular relative to any geotechnical investigation that's necessary. We're just looking for a variance on the setback. It was stated that the applicant bought the lots with the full knowledge of the setback requirements. Actually, the applicant was provided the covenants prior to the purchase of the property, and as I stated earlier, the covenants state a 30-foot setback off the north property line. So that's what the information was given to the applicant prior to the purchase. And then, I don't know how much you want to get into, but it's quite a bit's been talked about, the slippage of Mr. Betts's property. If you could turn on the topography layer, you'll see that there's a ravine or a stream that runs between the Riverby subdivision and actually there's two of them that run between Mr. Betts's property and our development, and it would be my suggestion as a civil licensed engineer that his slippage is related to the erosion of that creek bed that's adjoining his east side of his property. Has nothing to do with anything that's been done on Riverby. And as was stated by members of the board, the houses that are on Riverby, particularly 7333, which is piered, have been stable for 30-plus years. And we would intend the same investigation and engineering construction to be accomplished for the houses to be built on lots 22 and 23. Thank you.
Any questions from the board?
Did you say you were putting piering on that, in those houses at all?
We will have geotechnical investigations that specifically deal with the actual building sites. It would be my guess that they will recommend piering, but until we get that geotechnical recommendation, I can't say for certain, but based on the other structures that have been built in the area and the performance as such, they've all been piered and they've worked satisfactorily. So it'd be my opinion that the recommendation will be that we pier down to bedrock. And the pier would be intended to support the structure, not the hillside. That's the whole idea behind piering.
Well, during construction, who inspects it?
It would be Hamilton County Building Department. It'd probably be a special inspection, might very well be also required by a licensed professional engineer to do a special inspection on the footings.
And so Hamilton County would then be involved in determining whether piering is needed, or is it too late for them?
No. They certainly there are highly revised Ohio residential code regulations that would need to be followed relative to the foundations for the structures. There's also earthwork regulations, Hamilton County earthwork regulations, stormwater management regulations, and as was stated earlier by Mr. Betts, stormwater management of the site is certainly critical in the overall stability of that hillside. So there's stormwater management regulations, there's earthwork regulations, there are residential code regulations, all of which would specify what has to be shown for the plans examiner in order for them to permit the structure as it pertains to the foundation and the stability of that hillside.
So, in effect, the county would provide or inspect based on their capabilities and their expertise as to whether or not the property is going to have a detrimental effect to that land.
That's correct, and my experience would be they may very well, in addition to, when they make their approval, they may very well require additional inspections due to the nature of the hillside, which would, sometimes they'll specify that an independent licensed engineer needs to come in and also inspect it. But that's dependent upon the situation, and until that application's made for the permit, I don't know exactly what they'll require.
And so when the county then is assuming the responsibility, if you will, to satisfy the needs of the neighborhood and our topographical or geological.
Well, actually, the county's responsibility would be to verify that adequate information has been provided by a licensed professional, which that licensed professional is the one that would, in essence, take the responsibility for the performance of the structure in the hillside.
Okay.
Why is there a hardship to not build?
Well, the hardship is the vertical distance off of the pavement that's required relative to the 50-foot setback off the edge of pavement, the vertical drop of 10 vertical foot versus what we're requesting with our variance. So it's a hardship in essence that it provides a topographic obstacle to the access of the house, but also it does provide additional costs. And yeah.
So by building farther down the hillside, the 50-foot setback versus the 22 or 28 feet, I think it was, or 20 or 28 in question, you're trying to maintain the main level of the house to be the street level?
That's correct. We anticipate the front door in essence being, 6 inches, 12 inches above the actual finish elevation of the existing private drive.
And then the cost, the other part of that is the cost that you're associated with potentially building, farther down the hillside and the cost involved in structuring it better.
Well, I would expect the piering to be in essence the same, depending upon independent on where you place the structure. It's more as a matter of an access to the structure relative to where it is relative to the edge of pavement. So if it's moved to the north, the access would be more conducive to the hillside, and really quite what majority of the houses are doing out there currently, where they come in at street level or private drive level in this instance and access the house. Some of them go down a little ways, but I know Mr. Finn's house in particular, in essence, and then the 7333, that's directly to the west of Lot 22, that accesses at the elevation of the private drive. So the location is more critical relative to providing access to the structure as opposed to the foundation. I mean, the piering is going to be required whether it's 50 foot off edge of pavement or 22 foot off edge of pavement.
So more so the primary consideration is just putting it at the private drive.
Yeah, it's an aesthetic look as well as an access issue. If you move it back that 30 foot, you got to go 10 foot down vertically, but you're also, in my opinion, detracting from the character of that private drive, where you're looking at a rooftop as you drive down as opposed to a front door.
Will the existing retaining wall be,
That would be incorporated in the two houses, that's correct, we anticipate that. So we would expect that wall to remain as a stability for that existing private drive, and then we'd put in an independent piering system for the new structures.
Is that existing retaining wall, is that for the purpose of the house or for the private drive?
That's for the drive.
For the drive.
Well, within the frontage of our two lots, so the two vacant lots, but for the existing structure, 7333, there are piers that support that structure.
So it's really both in that case?
At the lot 7333, but at our particular lots where we're looking for the variance, it just supports the drive currently. And we would expect it to continue to do so. We don't want to add any additional load to that existing retaining wall system.
So the results of this geotechnical study could suggest that, more piering go farther down that drive back to where it comes down the hill?
Well, I would expect them to recommend that we provide piering for the structures and leave the pierings in place for the drive. So they would have two independent systems, one to support the driveway, which it's done for 30 or 40 years successfully, and then another piering system, I would suspect, for the proposed houses. And all the piers I would suspect would be recommended to go down to the bedrock, which is what the other houses out there typically do.
So according to this memo from Hillside Trust, they're basically saying that in our deliberation and consideration that we should request a thorough geotechnical investigation. Now, that being said, by those people, where is Hamilton County in this? Are they going to make sure that
I'm of the opinion they require that, but to me, it's far more important to the homeowner than anybody sitting here, because if they put $1.5 million, $2 million into a house, they want to make certain it's stable.
Yeah, it makes sense to me.
So there will be a geotechnical investigation provided, and it'll be demanded by the homeowner. But I'm of the opinion, I know the Ohio Revised Code has, the Ohio Residential Code has specifications relative to foundation supports and geotechnical investigations, and I know the Hamilton County earthwork requirements will control what you do relative to excavation of a hillside, as well as the stormwater management of that hillside.
That's it for me.
Any further questions or comments?
Could I ask a question of this witness?
Please do.
What's that?
Please.
Oh, thank you. Mr. Messer, did you do any geotechnical studies on either Lot 22 or 23?
We have not, no, but we will.
Okay, you have not done any.
Well, there's a geotechnical investigation that encompasses the entire development, so yes, in that regard, there has been a geotechnical.
I'm asking, did you or your client do any specific geotechnical
No.
study? Okay. And do you have any cost estimates as to peering on either the lots, either location, the current location or the current location?
The two alternatives? No.
Okay, thank you. Nothing further.
Any further questions or comments? Thank you. Are there no further comments from,
This is quick.
please?
Linda, my neighbor, tapped me on the shoulder and said,
You need to
Please
come up to the podium.
podium.
I was trying to make it quick. Linda, my neighbor, I'm John Adams. Linda, my neighbor, tapped me on the shoulder and said, hey, you might want to clarify, the lawsuit that's been thrown around regarding Andy Thole several years back was over trespassing, had nothing to do with slippage. She was a part of that lawsuit against Mr. Thole. Thanks.
Any questions, comments?
It doesn't say anything about trespassing in this letter from the Hillside Trust. Point of fact. Is that a legal term?
No further comments. Seeing no comments, and if there's no objection from the board, I will close this public hearing on case number 23, 2017 BZA and case number 24, 2017 BZA. The board will take this case under consideration and deliberate tonight. Thank you for everybody's participation. You're welcome to stay during the deliberation process, but at this point, the public hearing is closed. It is strictly a conversation amongst the board members and staff.
Mr. Chair, will my request be honored to review the minutes and review the applicant's additional new information?
The minutes will be published.
He's talking about last month's minutes.
Yeah, they'll be published. We disapproved them today.
Oh, okay.
So they'll be published probably a couple days, yeah.
Well,
And then you wanted,
yeah, I want to be able to comment on that and have that part of the public record.
okay, that's,
Now or when?
we don't have
Well,
time.
as soon as I get them, review.
We don't have time.
Joe, you were here last month, is that right? Okay. I'm not sure what benefit that would serve as far as commenting on the minutes. Obviously, you had the chance last month to put forward any argument about anything that was said or to ask questions or whatever.
I just want to see if they accurately reflect
Okay.
what was said.
Well, I think that what will be in the record will be the transcript of the proceedings that took place last month. The minutes are merely a summarization of the testimony, and obviously if there was an administrative appeal, for example, we'd use the transcript as opposed to the minutes. The minutes would be part of the record, which could be argued from, but the minutes are just, part of the record, so.
My only concern is if there's a misreflection in the minutes of
Yeah.
what I said or what was said last week, I want to be able to comment on that, and also the new evidence that was submitted
Okay.
tonight.
What new evidence did you want to have a chance to look
The
at?
applicant submitted something that I
Okay.
haven't seen.
I would suggest that we give him the opportunity now to take a look at that, what the applicant submitted, so that he has a chance to, make any comment on it.
Is that this paperwork here?
I believe so, yes.
Yeah, that'd be great.
It was a large stack.
It had this drawing.
I'll look at the minutes now, too.
Okay. Sure. You want to take a few-minute recess, Mr. Chairman?
Yeah, we'll take a 2-minute recess.
Okay.
We don't vote on that?
Since it's the beginning of the year and we have a couple of new members, actually, I'd like to introduce one of the members. He's in the audience. This is Don Skink. He's the second alternate. So he is, and then Kathleen has been promoted, I guess, to first alternate, and Jim Graff has been appointed to a regular member to fulfill the term of Fred's position. So since we have several new members, and it's always a good opportunity to have a training, we would like to schedule a training with the Board of Zoning Appeals with Gary. So last year, we had the training on a regular meeting date, and I don't know, for better or for worse, the next couple of months, we think we're going to have a couple more cases, and it may be too much to have the training on the same night. And I think Jim, you had some conflicts also
Yeah,
coming
there's
up.
no conflict, yeah.
So, I don't know if a day of the week works better for you all or not, and of course, depending on Gary's schedule, but if we want to look, you know, into, what, are you looking at January or February? We can look at either January or February, and then I would just need to check with the three members that aren't here. Well, actually, no, I'm sorry, Don's here, so we would need to check with the 2 members that aren't here. Do you all have a preference as far as days of the week? Or I guess for those that might be out of town coming up, are there certain weeks that just won't work?
In February, I think let me check the calendar. Maybe the 3rd full week in February, starting the 19th, I'll probably be out of town.
Okay.
Are we looking to try to do it yet this month?
It doesn't have to be. I mean, the sooner the better, but if this week, or this month is just too crowded, Gary is going to do training our zoning commission, so it may be too much to have both of them this month. You're tough. I don't know. We're going to do that one on their regular meeting date, which is January the 22nd. The trustees have their regular meetings on January the 18th, so I would prefer not to do it that night. And then January 22nd is a zoning commission meeting, but the other dates seem to be fairly open. And we usually do it in the conference room downstairs, so the room should be available.
And what time would we be thinking?
We can do it at 5:30 or at 6, and we'll provide dinner. So it'll be a dinner meeting, I guess you could say. So whatever works best for the board.
I'm retired.
Wednesday nights are better for me.
I was getting ready to say I prefer earlier in the week than later in the week, so.
That's right in the middle. It's right in the middle.
Don, did you have any?
Stuff on.
Okay.
Mine is full of stuff on.
I got a calendar I keep on my desk, and that's where
So we're, okay, back to be it January or February.
Yeah.
I like January better than, sooner than later.
Yeah, I prefer sooner rather than later. February gets a little bit more difficult, I think.
We could do, if Wednesdays, I don't know if the 17th would work for you, Gary, or the
24th? 24th?
17th or the 24th?
There's actually a 5th one this month.
Sarah, Brad?
The 24th will not work for me.
Does the 17th work?
I could do the 17th.
Well, let's tentatively schedule it for the 17th, and then we'll check with the other 2 members that aren't here.
Okay.
Would you all prefer 5:30 or 6?
6 works better for me.
6? Okay. An hour, hour and a half? Probably an hour and a half.
Okay, how do you put it in there? Did you just hit, oh, you hit the plus sign?
I was going to say, send me an email, I'll send you the invite.
Yeah, we'll check with our other 2 members tomorrow. Sarah, send you an invite. Brad, you wanna-
It's got something in there already. From that time frame.
No, it auto-filled the time frame.
Oh, it did?
Yeah. It'll just pick the closest time
Is
for
it
you.
listening to us?
It just picks the closest time. So if you put it in there at 10 p.m., it's going to put 10 p.m. as the default.
Oh, I didn't put anything in there. I have to check my calendar when I get home.
What's your email?
So you're not retired after all? Is that what you just said?
Yeah. I have to check my calendar. I got other things I do.
So what's your email address? I'll just send you an invite and it'll add it to your calendar.
I think they're ready. John.
Okay.
Deliberation.
I have no objection to minutes or the information.
No further comments? Thank you.
Thanks, Jeff.
There are no further comments from the audience. We will close this hearing for public comment, and now the board will deliberate amongst ourselves. Anybody wish to start off the, please?
212, 13.
We turn these off? No, we're on. We're in session.
I guess I think it's important to start off kind of going back to some of our training we did last year and kind of, reintroducing you or reminding you of your burdens or your duties under the Anderson Township zoning resolution and looking at an area variance. So there are two kinds of variances. One's a use variance, which requires a higher standard called unnecessary hardship. Okay, use variance would allow a use in a district that's not otherwise allowed in that district. So you have to, a property owner would have to show a fairly high burden of showing an unnecessary hardship to meet that standard for a use variance. In an area variance, the standard is called practical difficulties. And practical difficulties gives more discretion to the decision-making body, in this case, the Board of Zoning Appeals. And as the zoning code indicates in section 112, or 212, I'm sorry, where it sets out the standards for the area variance, it says standards to be considered and weighed in determining whether a property owner seeking an area variance has encountered practical difficulties in the use of his or her property include, but are not limited to, the following. So back in the day, there was a Supreme Court case called Duncan versus Middlefield that distinguished the standard, the unnecessary hardship standard, from the practical difficulty standard, and said that the practical difficulty standard was a lower burden for the property owner and gave the decision maker more discretion. So these are 7 factors from the Duncan versus Middlefield case that are to be used in determining, to be considered and weighed, as the zoning resolution says, in your deliberations. Now, one isn't necessarily more important than the other. They don't all have to be met, but these are to be considered by you in deciding whether the property owner has presented practical difficulties to basically justify having a variance granted. If you don't find that the property owner has met that burden of showing practical difficulties, then you should deny the variance. Okay? So there's been comment about buying the property knowing of the zoning restriction. And it used to be pretty much, at least in the use variance category, that was pretty much seen as a complete wipeout of your chance for a variance. Back in 2001, the U.S. Supreme Court decided a case called Palazzolo versus Rhode Island, which allows a property owner to challenge a land use restriction that was placed on the property prior to their acquiring ownership of it. So since that case, and the Ohio Supreme Court has also followed that U.S. Supreme Court case, saying that it's no longer an ironclad prohibition that you can't grant a variance when the property owners bought the property. They're saying if you acquire the property that has zoning issues on it, you should still be able to challenge those zoning issues. So by filing a variance, that's what this property owner is doing, is saying that we have a practical difficulty that we're being faced, and so we're asking for a variance from the other, from the front yard setback. So again, as you've talked about before, they still have to meet the height requirements and all other requirements of the Anderson Township zoning resolution, and they're only looking at, and I say only looking, I'm not trying to minimize the variance, but they're looking at an area variance, not any other kind of variance. So if you have any questions about that, I just thought it was helpful to get that out before you started your discussion, your deliberation.
Board members? Any comments? Questions, concerns?
My comment is that they're asking us to determine whether or not it's okay to waive the 50-foot variance, or restriction. And that's all I'm focused on. All the rest of it, I believe there are governmental organizations that are there to protect us as citizens and make sure that the property and the housing that's built on that property is going to meet standards that are not going to affect other people. And the objections that I've heard have nothing to do with the setback. They're all about land slippage and all that. And the leverage is trying to tell us our job and throw into our job something that we don't have expertise in, which is geological stuff. So long and short of it, in my opinion, is that I'm in favor of granting the waiver or the variance primarily because our only obligation in this particular thing is to deal with setback. And I don't see that as a burden to the neighborhood.
I think one of the things that was discussed is the need for, and the request is to do this geotechnical survey prior to building, laying out plans, breaking ground. It would seem to me, and I would agree that a full geotechnical survey, a lesser one, both of those, I think that would be accomplished. If it's done now, there's investment made by the parties to have this done ahead of time, to know better, where's the best way to position and come back to us later and either possibly request or even pull back that request for a variance. I would agree that the county, the building department, and all the parties involved would not want a house to begin to slip down this hillside. It's not in anybody's interest, in considering that the owner of these two lots already lives in that and plans on building on one of those lots. Nobody would want that. Regardless of the height restriction, the visibility, they're going to do the due diligence on their own whether or not that's requested of us.
Ms. Wagner, any comments?
I agree that there will be further things that will be looked into in order to get your permits and move forward, but we are looking at a variance only.
I have a tendency to agree. Are you done?
Yeah.
I have a tendency to agree. It kind of boils back down to, even with the council, it's stated too, it goes back to the law as well too. There's going to be, if there's liability issues too, it doesn't fall on necessarily fall on the county or the township. It's going to fall on the builders, the developers. They're ultimately responsible for making sure what they build is proper, protects not only the residence itself, also the surrounding homes as well too. So there are some means for, if something does go wrong, unfortunately, there are some means to address that, and that's technically not within our purview. Our purview is strictly with, does the variance make sense or not? Does it fall under our conditions here, the 2.1? And in my looking at it, I believe ultimately, based on the last meeting we had, they discussed, I believe it was like in excess of $1 million per house. The value of those houses alone indicate to me that they better be, they're going to be a very high standard. They're going to be very high quality. They're going to be properly situated too. I mean, anybody who's going to be able to afford those houses will certainly have their own attorneys on retainer if something goes wrong. So nobody's looking to put anything up, haphazard that's going to cause any issues. So I'm in agreement with the board as well. Are we ready to take a vote on the matters, on both cases?
Did they talk about a cost of the house or just a value of the house?
The last meeting, I believe they mentioned, do you remember where it was? Yeah, here on the page 5 of the minutes, worth approximately 1 to 1.25 million.
Because if they were evaluating a cost, you would think they would have done a geotech study to know how much the cost of the piering was going to be in that value.
Well, I don't think you're going to build a house at that cost and not make sure that it's going to stay in its place. That's just me, and I'm not an engineer, I'm a banker. So if I were a banker loaning the money, I'd make sure there was this survey done to guarantee that I'm not going to be getting a house halfway down the hill. That's where I come from. So.
Well, and it was presented that, at least in some examples, that the cost of piering, the cost of reinforcement, the cost of preventing slippage, we heard numbers circulating around from $10,000 or $15,000 to $100,000. And, to have a view, what I'll call $1 million view overlooking the Ohio River, and to invest even $100,000 to put a house that's not going to go anywhere seems like a reasonable investment to make.
Also, Mr. Betts's concerns, it was pointed out that there's a stream or something going down the hillside that, in effect, has caused some of the geological problems that he was addressing. So, and the fact that there's already a house built down below him, right next to the 2 lots that he's talking about, tells me, at least makes me think, I don't know if it tells me it, but it makes me think that that house would have caused trouble as well for him, so.
And Ms. Weber's testimony was that her slippage was not due to the hillside, but the developer error.
Yeah,
with
and
backfill.
but she's at a different lot. She's a little.
But she's on Riverby.
Yeah, she's on Riverby. Yeah, and that makes sense to me.
Closer to.
Yeah, you got to watch what the contractor throws in the ground. Anyway, nothing against contractors.
Well, it was that same house also had a variance that preceded this one of approximately the same setback that was approved.
There were a couple houses in the neighborhood that had variance approved.
So.
Well, this one is in that same path of going down the private drive. So that setback would be fairly consistent with the setbacks that we're talking about here on that same road.
No.
She had a front yard setback and a side yard setback.
Okay.
It's both like 30.
I'm done.
Any further comments? That being said, do we have a motion?
I move that we approve the request for the variance, and that it be done start it within 1 year and complete it within 2.
With a height condition of,
Based on the agreed upon notes on Exhibit A. I guess that's Exhibit A, isn't it?
We can reference the dates of the submissions.
Exhibit A dated January 4th,
No.
2018.
no, not the one that's stamped January 4th, the one that was submitted. But there's a discrepancy. This says 632 on B, and this one has the correct. It needs to be this one.
What, has it got a date on
How
it?
do we designate it? But this, okay. Yes. But it's
So what we do?
okay, we could You could go by the one that's dated January 4th.
3rd, January 3rd.
No,
she's got one
that
that says January
that one
4th.
has a discrepancy.
Look to this one.
I was thinking that there's...
Yeah, the correct schematic that was presented is dated January 4th. The other one is dated January 3rd, but was stamped as received by Anderson Township,
Okay.
January 4th. So if we use the January 4th one, I think that will clarify it.
Okay.
Using
The
the,
pre-printed date of January 4th?
Yes, pre-printed date of January 4th.
Okay, and I'll put the time, 5:30.
Okay.
You want this one?
in the height restriction based on the Exhibit A submitted on dated January 4th and received January 4th at
5:30 PM.
5:30 PM.
Any amendments?
I don't have any.
I would propose that we split the motions out for the two different cases separately.
So I'll move that we approve on Lot 22,
The cases?
case number 23-2017. There's one approval, and then the other one would be case 24-2017. So that's my motion. I didn't do it in order, but
Do we have a second?
And amended for a start within 1 year.
yeah, I already said that.
Oh, you did, I'm sorry.
That's
I
what you
didn't hear
Control that.
That was early on.
Staff has captured that, too. They're faster than us.
Yeah.
Do we have a second?
A second.
We have a second. Will the secretary please call the roll?
Mr. Halpin?
Aye.
Mr. Graff?
Aye.
Ms. Wagner?
Aye.
Mr. Sion?
Aye.
I think what we're going to do tonight, that he said is okay. I think we're just going to take the straw vote tonight, and then we'll draft the decision, and you can journalize it at the next meeting. That way, we'll have time for legal counsel to review the draft.
I didn't hear what he said, but
We're just going to,
We're not going to make a decision. We're not going to journalize tonight, so we'll do it at the next meeting.
okay.
So give me 1 second.
Okay. Can I call the meeting to a close, though?
Oh, yeah. Yeah, that's fine.
Thank you.
Motion to adjourn?
I move that we adjourn the meeting.
So noted. Session closed.